Well, first of all, thank you very much for having me here. There's an old saying that you can tell an awful lot about a person by the company he keeps. And you've really assembled the A-team here the last 2 days, and I feel very privileged to be part of it. Seems to me that to begin talking about bullying cures and regulations, the best place to start is what's sometimes called the pediatric safety system, the private and public system that is designed to protect children both in the home and outside. And the beginning of the pediatric safety system, make no mistake about it, are the parents. But when parents falter or when they can't do it themselves, when they have to send their kids to school, for example, and hope that they'll stay safe all day, public agencies, the law says to public agencies that you've got to play a role as well. I'd like to talk about the public school system today. The pediatric safety system works best at the top of the hierarchy rather than at the bottom. The further we go down to the bottom, the more likely it is that we're going to have public intervention only after somebody who might be 10 years old, only after somebody has really been hurt. The public school system is really at the focal point here for 3 reasons. First of all, most school-age children attend public school. Most bullies know their victims largely or entirely from going to school, and most bullies anticipate a reaction only from their classmates, because the rest of the 2 billion people who watch the internet could care less. So I'd like to talk to you about the 3 Ps today: perception, prevention, and potential legal constraints. Each one of these has public policy implications, I think, and also legal implications. Taking perceptions first, public policy law often depends on perceptions. Now, no analogy is perfect, but it's helpful to think of bullying victimization as something that imposes a learning disability on its victims. Why? Because it imposes barriers to education, very similar to the sorts of barriers that Congress sought to meet in 1975 when they passed the Individuals with Disabilities Education Act, the IDEA. Like the IDEA recognized disabilities, bullying victimization jeopardizes the public obligation to provide a free public education to all children, or as we say today, we leave no child behind. Now, the IDEA, to keep the analogy going, recognizes a lot of congenital disabilities, but it also recognizes disabilities that come from external circumstances, very similar to bullying victimization. As we learned very well yesterday, kids can't learn effectively when they're scared stiff, when they're worried about their status, they're worried about their physical safety, and so forth. So I don't suggest amending the IDEA, but I think that perceiving bullying victimization as imposing a learning disability is something that can motivate legislatures to do the right thing. And although 49 states now have bullying legislation, there's still a ways to go in the amendment process to make sure things work right. And they can also energize schools to protect kids, to engage, to experiment with successful with prevention programs, and also discipline kids whose behavior falls outside and evades prevention. Now, as far as prevention is concerned, I don't think I need to say too much about it, because yesterday things were said so well. I think that Plan A has got to be continuing to learn what works and what doesn't work in the way of prevention. There's an old saying that if your only tool in your toolbox is a hammer, your problems all begin to look like nails. And most lawyers, all lawyers, they're graduates of law schools. What do we teach in law school? We teach students that every problem has a judge, a jury, a courtroom, complaints, answers, and testimony. Well, we need to be very wary of legal solutions here because they're not always solutions at all. We cannot begin to prosecute or adjudicate or discipline our way out of this problem. The numbers are just too large. Bullying, there's just too much bullying going on, and we shouldn't want to rely on prosecution, juvenile court adjudication, and prosecution, because the prosecution cannot make a victim whole usually, or discipline. These are reactive measures. They apply only when they're invoked only when somebody is already hurt. These measures cannot usually make somebody's life better. They can only make them less worse. And also with zero tolerance policies, safe schools acts, other such measures, we already throw too many kids into the formal process, too many kids into the criminal justice system, the juvenile court system, for behavior that schools used to be able to handle for themselves. And I think that if public authority serves children best when we're able to modify behavior in a preventive mode without formal processing, and leave formal processing to the most serious cases, which certainly do exist. As far as potential legal constraints are concerned, I could spend the rest of my time talking about that, and I realize I'm not, well, no, I guess I'm up to date. I tend to talk faster than I press the button sometimes. Let me front load the rest of my presentation and give you 3 conclusions, and then we'll talk about them. The first conclusion is that the law is very often a major impediment to protecting bullied children. Now that I have your attention. Schools face strong disincentives to enforce state-mandated anti-bullying legislation. Some of these incentives are professional, some of them are financial, many of them, maybe most of them, are legal in one way or the other. Second, and the reason for these disincentives is that every time you discipline a child in a public school for bullying or anything else, you don't know whether the parent's going to have a lawyer in the principal's office the next day making you look stupid. So the second conclusion that I'll draw is that when lawsuits are brought by parents and bullies, they're usually they're always asserting legal rights. They're usually asserting constitutional rights. We ought to take them seriously, but we also ought to take seriously the rights of victims. Third, the existing law, I think, puts school districts in a strong position, but it's not a slam dunk, it's not ironclad, and there's still plenty of room for lawsuits, and these lawsuits occur. Now, taking disincentives first, since we're in Washington, I guess it's appropriate to quote Tip O'Neill, the former House Speaker, who said that all politics is local. Well, ultimately, all enforcement of state-mandated anti-bullying legislation is also local. It depends on teachers, it depends on administrators, people who are in the building, who are outside the direct supervision of the state legislature, no matter what the statute says about reporting obligations and so forth. And sometimes this local will is seriously tested. For one thing, anti-bullying legislation is almost always unfunded mandates. The legislature says the school district has to do this or that, and who pays for it? The school districts, who are strapped for money, have to hire faculty, train faculty, use faculty time, buy materials, and so forth. But that's something that can be cost effective, I think, and it can work. But the greatest, and some of these legislatures really have a lot of work to do. I'll just give you one example. Most of the legislation, most states require school districts to have policies against cyberbullying. Most of the statutes that require policies against cyberbullying also specify that the statute applies only to discipline that's imposed for what a child does in school, on school grounds, or on a school bus or a school-sponsored trip, when they ought to know that almost all cyberbullying emanates from off campus, which means that the cyberbullying ban doesn't mean very much at all. But anyway, the most expensive cost of all is the litigation that can come and having to defend a lawsuit. It is very expensive in this country to defend a lawsuit even if you win. And school districts have to face that, and the state legislation normally does not help school districts fund legislation when some parent brings a lawyer into the principal's office a few days later. There are disincentives that are professional and financial and not necessarily legal. Lawsuits depend upon the facts. They don't just depend upon the law. Courts apply the law to the facts. And it is not always easy in some cases to determine who did what to whom, and it becomes a he said, she said, so that's a problem. But the point is that even if once the school district knows what's going on, the question then becomes, are you willing to pay for defending a lawsuit potentially? Sometimes the path of least resistance in the public schools is to turn your back on student misconduct, because you don't want to have, particularly if you're a young teacher, you don't want to have somebody in the principal's office with a lawyer leading the school board to back down so they don't have to pay for a lawsuit. Now, as far as legal authority is concerned, bullying legislation is relatively new. It's about 15 years old. Bullying lawsuits then are relatively new, and the law is sometimes very slow to catch up to reality. But I think the law is there to protect school districts. This is not going to protect them from a lawsuit, but it ought to enable them to prevail if they put on the right kind of evidence. Because the Supreme Court's been clear for years that schools are special places. And the point is that students' rights, including constitutional rights in the public schools, are a lot less than what rights are outside the school, because not only do you have to weigh student rights, but you also have to weigh student protection, and that the court has been saying for years that schools are special places when it comes to school discipline. Give you one more slide. All right. Now, here's what I mean by potential legal authority and strong position of the public schools. No student has defeated a school district in the Supreme Court in 40 years. Every time a student has lost a battle in the Supreme Court, the court has clarified and strengthened school authority to discipline students, including in cases that involve their constitutional arguments of their constitutional rights. Schools are seen to be special places. Now, the seminal case is a case called Tinker versus Des Moines School District. The Tinkers and a couple of their friends in 1967 wore black armbands to protest the Vietnam War. And the court set up a test that is still applied today, that a school can discipline a student for material and substantial disruption of the work of the school or collision with the rights of students to be secure and let alone. Well, if you take these two-part tests, this sort of sounds like bullying, doesn't it? Disruption and security with the right of other students to be left alone. In 1986, the court decided a case called Frazier. The young Frazier gave a lewd speech in a school assembly program, was suspended and raised a First Amendment claim. Schools have the right to teach values of the social order, sensibilities of public fellow students, the boundaries of appropriate social behavior. This also sounds like bullying, doesn't it? And I'll just skip these last two cases where the court is talking about inculcating cultural rights. The court has also said that student speech gets even less protection when it's non-political speech. The Tinkers wore black armbands to protest Vietnam. Hardly any bullying or cyberbullying has any political connotation at all, so that gets even less protection at all. The Supreme Court has also been clear that the lower courts, federal and state, ought to defer to public school districts when it comes time to disciplining students. So you put all this stuff together, the the school has a strong position, but that doesn't necessarily mean that they're going to win unless they want to fight a lawsuit. Now, just very quickly, because I'm seeing the red light here, 2 other claims very quickly. Assaults are not protected at all, and most bullying involves assaults. So does most cyberbullying eventually, because students beat up on one another after they cyberbully a lot of times. Also, threats, even verbal threats, no First Amendment protection. So a school district could discipline the threat or discipline the assault without even getting to speech. Now, I'll talk about off-campus origin of cyberbullying during the Q&A if you have time. I had a nice vanilla conclusion for you, which I'm not going to deliver because I rewrote it this morning based on what I heard yesterday. And what I heard yesterday was this whole discussion of law talks about what is it's so important what we heard yesterday. We know that bullying hurts kids, but we also know that the law protects bullies. And it means what we heard yesterday and what we heard this morning, which was excellent, doesn't mean much if schools are reluctant to exercise their disciplinary authority. So the law moves slowly, and I would hope that I've heard that we might have a report coming out of what we're doing these 2 days. I would hope that we also have some friend of the court briefs in litigated cases to try to explain to the judges what bullying does to kids, because all the tests that we had, material disruption, substantial disruption, cultural values, these are standards that do not apply themselves. There's an awful lot of discretion. And we need to start with the trial courts, then move to the Court of Appeals, then up to the Supreme Court. In the meantime, school districts just have to be willing to fight lawsuits in order to protect kids. Now, in the Supreme Court, if you went on for 30 seconds or even more than that with the red light going, you'd almost get disbarred, so don't do that to me. But other things we'll talk about during the Q&A, and thank you very much.